Mr. Charles Adeogun-Phillips joins us now. He's a former international prosecutor at the United Nations. Thank you for coming on this morning.
Thank you for having me.
Well, let's start off with this ongoing fuel subsidy bribery allegation making the rounds and then take it from there, because, I mean, you've also been following some of these matters. Yes. People look to the judiciary now and say, oh, there, maybe, just maybe, they may play that big role to ensure that at the end of the day, prosecution is done. What do you think about what's going on?
It's rather unfortunate in the sense that the oversight functions of the National Assembly has been called into question once again. As you know, they have two main functions, a legislative function and an oversight function. We have seen a reoccurrence of the oversight function of the National Assembly being called into question, and this particular case is quite peculiar. It's interesting, and one would be interested to see how things might unfold. Can
we say the oversight function also includes the summon which they gave to maybe one of those enmeshed in all of this, now like Femi Otedola, who was there at the Ethics and Privileges Committee of the Assembly?
Yes. The National Assembly, as you know, as part of its oversight functions, has the right and the power by the Constitution to actually solicit evidence from citizens when matters have to do with the disbursements of funds appropriated through the National Assembly. So they're quite within their right to actually summon individuals to actually appear before the committee of the National Assembly. But in doing that, they also have to be mindful of Section 35 of the Constitution, which actually allows individuals the right to silence and the right against self-incrimination. And what you saw there was that Mr. Otedola decided to exercise his right, which is a constitutionally guaranteed right to silence.
Even though he appeared there?
Absolutely, he has a right to silence. You and I have a right to silence under Section 35(2) of the Constitution of this country.
Okay, but yeah. Okay,
just yesterday, the House of Reps came out to clarify why he was invited, that he wasn't the subject of the investigation, but a witness to the investigation they're conducting on one of their own. So in that particular instance, isn't it possible for him, because how would they be able to hear the allegation of bribery against one of their own without exactly listening to the other side, as it were?
That is indeed correct, and that's what I've said. They're empowered under the Constitution to actually take steps to interview witnesses and to procure evidence. There's no dispute about that. The problem they have in this case is that the witness they seek to elicit the evidence from may also be a suspect in a criminal trial. In that case, he then has a right to protect himself from self-incrimination, because no one knows where this is going to end. So on the one hand, you have an obligation and you have a constitutional right to procure evidence, and which is what they've sought to do. But he also has an individual right, constitutionally guaranteed, to his silence. And that's what he's done.
Doesn't that put the Ethics and Privileges Committee in a very dire situation, as they might not be able to do any conclusive investigation on that?
Well, it does, in the sense that the investigation that they have started may have been premature because of the implications of bribery and corruption under the Criminal Code Act or the Anti-Corruption Act. These are crimes that carry severe penalties of 7 years imprisonment without an option of fine. So both the giver and the taker may be liable to criminal sanction. In those circumstances, they should have allowed the law enforcement agencies to exhaust their investigations before they started the internal investigation.
And besides, what's the limit of this Ethics and Privileges Committee in criminal prosecution? Because some say this is a criminal matter. What role does this committee play?
The Ethics and Privileges Committee, like many other committees, is established to investigate matters, internal matters, concerning members of the House. Mr. Otedola is not a member of the House, so like your colleague has rightly pointed out, was invited as a witness to an allegation. So He's not subject to the sanctions of the Ethics and Privileges Committee. He can assist that committee in reaching conclusions on a certain matter, and that's what they've sought to do, but it's premature.
Well, it brings us to the talk of corruption, because all of this is all about corruption, and any time we think or we thought we're getting close to nipping it in the bud, we have this blowout.
Yes.
So when we talk about the fight against corruption, looking at the EFCC, talking about the police that is also carrying out investigations, and you try to marry that with what the House committee is doing, can we actually get a head start and say this is the way to go? Because the way it is now, our last guest here, we're talking about the evidence that were brought before the law courts. They say, well, some of them have been destroyed by being played on air, and everyone has turned out to be a judge. But what's the role of the police and the EFCC in all of this?
White-collar crimes, and what corruption is an element of white-collar crime, what we call paper crimes, are extremely complex in nature. They require specific skill. What we need to have in the fight against corruption are specialized courts and prosecuting agents that understand what it is to prosecute white-collar crimes. In England, it's called the Serious Fraud Office. In New York, they have a department that deals with it. They only specialize in paper crimes. Now, we have something similar here where they call, I think it's the Special Fraud Unit in the police. I'm not so sure how well-versed they are in specific issues of white-collar crime. The reason why they're complex is that they leave a paper trail. You almost need forensic accountants to help you understand the transactions that take place in a complex white-collar crime. And it's not only limited to corruption. It could be economic, it could be financial. The point is, the time has come, to my mind, to actually divest the political functions of the Attorney General's office from his legal functions.
How?
By dividing those functions. The Attorney General does not necessarily have to be a politician.
Okay.
The Solicitor General is not. The Accountant General is not. You can have a Minister of Justice who is the politician, who formulates policies for courts, for what have you, appoints judges and all that. And you leave the Attorney General to do what Attorney Generals do, prosecute crimes and litigate on behalf of the government of the Federation.
As it is now, does it smear the whole effort of prosecuting crimes?
Well, the structure that you have at the moment is a little complicated in the sense that when you have one person fulfilling both a legal and a political role, there might be political considerations being brought to bear. The easiest thing to do, basically, is to let him do what lawyers do, just separate the two. Let somebody else do the political work and let him focus on what lawyers do. And then have departments within the Attorney General's office, one for white-collar crimes, paper crimes, economic crimes, other for drug enforcement or customs and excise violation or revenue. So white-collar crime consists of violations of, if you don't pay your taxes, tax violation, revenue crimes, economic crimes, financial crimes, and corruption. They're all elements of it.
Does it then mean that since we don't have special courts yet for these kind of matters, we won't go anywhere with this case?
No, you would. Absolutely, you would. You would. You can have the cases being litigated before the state high courts or the Abuja high courts, or in some cases the federal high court. It is not the forum of litigating the case that is the problem. It is the preparation of the case and the formulation of a prosecutorial strategy that is lacking. Your case is only as good as your evidence. And that is where the problem is. You need people who have the means and the know-how to build complex trials, criminal trials. Now, if you have the evidence and you've been able to build the trial, then you wouldn't have any problem convincing a judge of your case. You
know, initially when the report was given to the executive, handed over to the executive arm of government, a group called the Save Nigeria Group asked for an independent prosecutor because there was also a problem of confidence. So would you recommend that in this particular instance, do you think that an independent prosecutor could have been able to fill that gap?
A special prosecutor, yes. That's what is done in many jurisdictions.
A special prosecutor?
A special prosecutor is an independent prosecutor. It's someone you bring in from outside the system. So he's not part of the the machinery, as it were. He's not part of the Ministry of Justice. He may be a private practitioner. He may be someone from abroad who is qualified to practice here. So you bring in a special prosecutor who is devoid of all the political considerations, of all the institutional considerations, to build his own team and prosecute. That's true, especially in a case like this that involves entrapment.
One would, sorry, Mark, but one would thought that we shouldn't even be in this kind of scenario. We thought we had too many of them already. You mentioned the police special front unit.
Yes.
We have the EFCC. We also have the ICPC. Shouldn't we be having a fantastic moment fighting this corruption we all talk about, or should we be talking about some kind of measure?
Well, what you have at the moment are different agencies that investigate. The focus of those agencies is on investigation of various types of crimes. There is no reason why the ICPC can't do what the EFCC does, or the EFCC can't do what the ICPC does. The ICPC just focuses on public officials. So you have an entire agency who just specializes in crimes committed whilst in public office. And you have another agencies whose functions overlap whether you're in public office or not. Well, why can't the EFCC do what the ICPC does? But in any event, those institutions are investigatory in structure. They are not set up with prosecutorial functions in mind. Now, the prosecutorial function rests with the Attorney General. So whilst you have all these agencies, all they can do is investigate crimes. But they have to do it under the guidance of someone. So who directs their work?
And you said that that person must not be a politician, or should not be a politician.
Well, I mean, for the integrity of the whole process. For the integrity of the whole process, it must be someone who is devoid from the whole political process. Someone has to direct the work of the agencies. That's where the link is lacking. You need a specialized prosecutor who is able to direct the work of the NDLA, the ICPC, the EFCC, and any other agencies that is involved in the investigation of crimes.
Maybe this will be pushing it by half a mile, but is there anywhere, say, in the statutes guiding the ICC, International Criminal Court, where economic crimes could also constitute crimes against humanity?
No, but not by a long shot. not by a long shot. We can put the funding of terrorism so far, but again, that will be pushing it. And the problem is this. Even terrorism can be prosecuted by the International Criminal Court, but it can only be prosecuted when it's conducted in the cause of an internal armed conflict. So unless you have an internal armed conflict in your country, you cannot refer your case to the ICC for prosecution. But economic crimes, no. We can try piracy, by the way, which is, there's growing need for international piracy to become an international crime.
What's the difference in armed conflict, terrorism, militancy?
Well, armed conflict in the sense that there has to be insurgency, there has to be like a civil war ongoing, and that the acts of terrorism are targeted at civilians who have no active role in the conflict. That is what a crime against humanity is. It's targeting civilians on racial, political, or religious grounds. Do you understand? And that could be the case of which we have here in Boko Haram, but it has to be in the context of an armed conflict.
Okay, let me just clarify. I need you to clarify this before we continue on this terrorism matter, because I've heard lawyers talk about the fact that when cases get to court, administration of justice becomes a big issue. And then you also talked about the fact that some of these agencies that were set up were not set up with prosecution in mind.
They're not.
Do we need to restructure? And what should we do? How should we
Well,
go about
I think the restructuring is necessary. It's long overdue. One of the main points to restructure is to have established offices, or one office of a special prosecutor or an independent prosecutor, whatever you choose to call him, who supervises. You see, investigators are essentially law enforcement agents, and they cannot fulfill their role. The goal of an investigation is to gather evidence to help me as a prosecutor succeed in a case at trial. So it goes without saying that I have to direct that investigation. You can't do your investigation without me. You're helping me. I have to stand up in court because my case is only as good as my evidence. So if you go off on a frolic of your own to investigate, or like they do here, try people on the pages of newspapers when you have very little evidence in the back, and then you send me the file, which is completely empty, I'm then a lame duck. I'm a sitting duck in court because I have nothing to base my prosecution on. So you actually need an office of prosecutors that actually supervise those agencies when they have investigations to carry. What are you going to do? How are you going to do it? This is what I'm looking to achieve, and this is what we're looking to charge.
What do we expect from this matter? Because if the police say, we've handed over investigations to ICPC.
Yes.
One wonders then, I mean, what is it that ICPC can do that the police couldn't do?
Well, there's an overlap. If you look at the Criminal Code Act, there's an overlap in the Criminal Code Act which deals with the offense of bribery and the Anti-Corruption Act of 2000. Both of them deal with the same crime. One focuses on public officials, one doesn't. The penalty is the same. So the police can do it and the ICPC can do it. Either way, they would both end up before a state high court for prosecution. Now, this is an interesting case because to all intents and purposes, Mr. Otedola has been used as what in French they call an agent provocateur. It's an incitement agent, an agent for incitement. It's a French term. And what that does is that law enforcement officers are allowed to conduct sting operations using individuals, but it has to be done in such a way that you ensure that you don't provoke someone else who would not otherwise have committed an unlawful act to do so. So there's a thin line between asking an agent to help you, an agent provocateur, to prove that somebody is capable of committing a crime, and entrapping. So the likely defense in this case, for example, is, well, I was entrapped. The main standard to prove entrapment is whether or not he would otherwise have committed the crime, having not been induced or provoked to do it.
So you have to go to history.
Because
or sometimes precedents.
It's factual. It's purely factual. It's purely factual. It's based on the facts. We don't know the facts of this case. There are tapes running all over the place. But the inducement factor is what determines whether or not he was entrapped or not.
Well, another issue, sorry, getting my bad. Another issue has to do with our laws. Sometimes people feel that maybe we have inadequate laws. Specifically speaking now, a case in point is the AGF asking the ICC to intervene in the Boko Haram issue.
Yes.
How does that make sense?
Well, it's unfounded in the sense that the ICC lacks what we call the subject matter jurisdiction. Subject matter jurisdiction is matters that can come before the ICC. Now, like I said earlier, terrorism, the ICC has jurisdiction over the crime of terrorism, but only when it's committed in the context of an armed conflict. We don't have an armed conflict here, so it has no jurisdiction. Secondly, the jurisdiction of the ICC is purely complementary. In other words, it complements that of the state, referring a matter to it. So the ICC's jurisdiction is only triggered when you are unable or unwilling to prosecute crimes yourself. So when you refer a matter to the ICC, you're in essence saying, well, we can't do it ourselves.
So does that mean it's not a court of first instance?
It's a court of first instance.
It is.
It has two chambers. It has a trial chamber and an appeals chamber. It is a court of first instance, and it's subject to appeal within the ICC itself. It has two chambers within it.
Okay. So quickly, let's just drop this in. The meeting between the president and the chief prosecutor of the ICC, that was about 2 days ago.
Yes.
What do you think that they talked about?
Well, I think in essence that meeting would have been, first of all, to show her gratitude to Nigeria as a major supporter of her candidature, because she's only been in the job a week or 2 weeks. And I think Nigeria played a very important role in having the first female African to head such an international institution. So as, on that basis, it would have been to express her gratitude. And secondly, would have been to express support. Because whilst I say terrorism in itself does not come within the jurisdiction of the ICC unless it's committed within an armed conflict, the actions of Boko Haram constitute crimes against humanity. Now, so we have to identify what it is we're charging. You can't charge them with terrorism because it's not as a war crime, because it's not being conducted within an armed conflict, but you certainly can investigate them for crimes against humanity. Reason being, their actions are targeted at a civilian population and it's based on religious or ethnic grounds. So her cooperation at some stage would be necessary.
You know, let's bring you back to this report. Do you think that the credibility of this report has been affected by, you know, all the circumstances surrounding it presently?
Well, I'm going to speak to you as a prosecutor. And when I started speaking to you, I said, the major rule for any lawyer, for any prosecutor, your case is only as good as your evidence. Now, so what is the value of a report that whose integrity has been called to question? That is really the point that people have to ask themselves. Should there be another committee, for example, to look at this all over again? In essence, the reaction of the National Assembly in reversing itself on a previous decision to exclude certain names from a report already indicts members of that House, in the sense that it's almost acknowledging that there was some wrongdoing, there was some impropriety. I think they should have just stayed the matter, allowed the law enforcement agencies to do their work, and the results of any investigations or prosecution should have then influenced what they do in the House, rather than just run back into the House and reverse themselves. It kind of leaves
a little more to be desired. But that's your answer as a prosecutor, your answer as a Nigerian.
Well, I mean, it's no different, really. I mean, what is left of a report that has been subjected to so much scrutiny, so much allegation of wrongdoing? Names are being pulled out and pulled in of this report. Money allegedly is changing hands. What's to say that 20 other names in there haven't remained in there because people refuse?
But some people claim that, you know, that was the plan all along, that the plan was so that report would never get to see the light of day. When finally it did, the idea was to discredit it and make sure that, you know, no action can be taken on it.
Well, then in that case, those who were empowered or entrusted to write the report should have been a little bit more circumspect, knowing the reality of the situation.
Because they knew that from the onset. They said, listen, they're going to come at us.
If you know that there are political forces that will be wielded against you because of the implications of what you're doing, it's more reason that you be circumspect and you exercise caution and everything.
Okay, assuming without conceding that this House of Reps report, big question mark on it, can we then look to perhaps the Senate committee?
Yes.
Because they started their sitting before the House of Reps.
They did.
So if they come up with their recommendation and is devoid of all of these distractions and possibly entrapment, can that be tenable?
There's no reason why not. The House of Assembly, the House of Legislative is one body. It's divided into two segments, the lower house and the upper house. The Senate can conduct its own investigation, and there's no reason why that report shouldn't stand, if that was the case. Absolutely.
So if the National Assembly is looking to perhaps, let me say, for want of words, save its face, the Senate can come up with that report and then recommendations to the executive arm of government.
Maybe not reinvent the wheel, but actually maybe just re-examine what the lower house has done and review that report for consistency, for accuracy, rather than reinvent the wheel all over again.
Well, with the gale of probes and reports all over, especially from the National Assembly, is that an indictment or a failure of their oversight functions?
It calls the whole essence, it calls the whole process of oversight into question. If you read the Constitution in Section 88 and 89, there are very far-reaching powers given to the National Assembly. The legislative powers are there, but the oversight powers, it gives it very extensive oversight powers to investigate what happens to money appropriated through the National Assembly. We've had one too many of these problems this year. It's one probe after another whose credibility has been impeached. I think the time has come for the management of the National Assembly to actually take stock of what's going on. I mean, the point has to be made. The actions of one man certainly has no bearing on the legislature as a whole. But clearly, it leaves a very bad image.
Let me take you back to this terrorism matter. From what you've seen about our terrorism laws, what can we do about it? Is it I mean, you've been at the international level, you've seen how it goes. What do we need to do here to ensure that those, because there's a case that is currently on and it's taken almost forever.
Well, you know, I think first of all, there's a disconnect and there's a misunderstanding between militancy and terrorism. And they're two different things.
Tell us about it.
One is internal, one is international. And it's almost like genocide and crimes against humanity. There are cases, very rare cases in life, where the international community would actually refrain from describing something as a genocide because of the implications, and would describe it as a war crime against humanity. The implications of this country being noted as a terrorist sponsoring country is grave. And I'm not surprised that there is serious attempts being made to not to call a spade, as it were, and to actually describe it as militancy. To fight terrorism, you need very enhanced counter-terrorism mechanisms. We are being reactive as opposed to being proactive. You can roll out 200,000 tanks after the act. That's not going to prevent the next act. It's to find out who the terrorist's wife is, who his brother is, which school he goes, which neighborhood he lives. He must worship somewhere, he must drive a car, he must seek medical attention somewhere. It's the counterintelligence. He has brothers, he has cousins, he has in-laws. It's the counterintelligence that you use to fight terrorism, not the military arsenal. And until we understand that and we put those mechanisms, and it's not cheap, by the way, it's a very expensive process to send intelligence people out and send feelers out, both within and outside this country. To gather the sort of intelligence, you need to know that a bomb or a terrorist threat is about to go off on 3rd Mainland Bridge before it happens.
Yeah. What if the sending out of some of those tanks is done on the complementary level?
Complementary in what sense?
Complementing the investigations, the counterterrorism acts, because I mean, if they're going about the counterterrorism ways, are they supposed to let everybody know what they're doing?
It's after the fact, though. The tanks go off after the fact. How does that stop anyone? It's been done. The Semtex has been planted under a tree. It's gone off in a shopping mall. Lives are lost. Roll out 200 tanks. They're already preparing. Whilst you're rolling the tanks to that venue, they're preparing the next one. It's the intelligence that you use to fight terrorism. It's as simple as that. We either have it or we don't.